$100 import. In February, the Supreme Court kills Trump's emergency tariffs. But on July 24th, that same shipment arrives with another $12.50 due at the border. The ruling still stands. So what changed? The answer is the law printed on the customs form. In fact, it changed twice. The court closed one route. The administration immediately moved to a temporary route. And as that route expired, it activated a third one designed to last. This was not one tariff coming back from the dead. It was a legal relay race. And the baton was the power Congress had already handed to the executive branch. The first route was IEEP, the International Emergency Economic Powers Act. IEEP gives presidents broad authority during a declared national emergency. It allows them to block property, restrict transactions, and regulate imports. Trump argued that the power to regulate imports included the power to tax them with tariffs. The Supreme Court disagreed. The statute never says tariff. It never says duty. Congress knows those words and uses them in other trade laws when it wants to authorize a tax on imports. So on February 20th, the court held that IEEPA does not authorize presidential tariffs. That ruling mattered. It destroyed the legal foundation beneath the emergency tariff program, but it did not hold that presidents can never impose tariffs. It held that this particular statute did not provide the power. The court locked one door. It did not confiscate every key in Washington. The administration did not wait 5 months to respond. On the same day as the ruling, Trump announced a 10% import surcharge under Section 122 of the Trade Act of 1974. Section 122 addresses serious international payment problems. It allows a temporary import surcharge of up to 15%, but there is a timer attached. Without an act of Congress, the surcharge cannot last more than 150 days. The new 10% surcharge took effect on February 24th. Its expiration date was July 24th. That gave the administration a bridge, not a permanent home. And while the clock ran, the United States Trade Representative built the next route. On March 12th, USTR launched 60 investigations under Section 301 of the same Trade Act. Section 301 is not an emergency shortcut, it is a different machine. USTR investigates whether a foreign government's acts, policies, or practices are unreasonable or discriminatory, and whether they burden United States commerce. The process includes consultations, public comments, hearings, formal findings, and a proposed response. Most importantly, Section 301 expressly authorizes duties. That word changes the legal argument. Under IEEPA, the administration asked judges to find tariff power inside the word regulate. Under Section 301, Congress wrote tariff power directly into the statute. Same economic weapon. Different legal key. The 60 investigations were officially about forced labor. The United States already prohibits imports made with forced labor. USTR argued that major trading partners had failed to create and effectively enforce comparable import bans. The government's strongest case is straightforward. If one country blocks forced labor goods but other markets accept them, those goods do not vanish. They continue through global supply chains, undercut producers using lawful labor, and can be redirected into the United States. USTR consulted more than 45 governments and held 2 rounds of public hearings. It received more than 2,100 public comments across the investigation and proposed action stages. It ultimately found that every investigated economy's policy burdened or restricted United States commerce. The final action set a 10% rate for 17 economies that had a ban, a commitment, or a partial system. Most of the remaining economies received 12.5%. Certain products from the European Union, Taiwan, Japan, South Korea, and Switzerland received special calculations tied to their normal tariff rates. There are also exemptions for scarce raw materials and products that cannot be produced in sufficient quantities at home. Goods already subject to Section 232 tariffs are excluded, as are products whose inclusion could create wider economic disruption. So be precise about the headline number. The 60 targeted trading partners supply 99.4% of United States imports. That does not mean this program taxes 99.4% of every imported dollar. It means the policy reaches most goods from the partners responsible for nearly all American imports, subject to substantial exemptions and special treatment. That is still an extraordinary footprint. A targeted forced labour action usually stops a shipment suspected of containing prohibited goods. This policy does something broader. It taxes most goods from an entire trading partner until that government changes its import rules. Those goods do not need to be made with forced labour. The tariff is pressure applied to the country. That is why two descriptions can be true at once. The policy can create a real incentive for governments to block forced labour imports. And the same policy can rebuild much of a global tariff wall after the Supreme Court removed its original legal foundation. At 12:01 on the morning of July 24th, the temporary Section 122 surcharge expired. At that same moment, the new Section 301 duties took effect. No dramatic gap, just a different citation. Now return to the $100 shipment. The foreign government does not send $12.50 to Washington. The legal bill goes to the importer of record in the United States. That importer can absorb the cost through lower profit. It can pressure the foreign supplier to lower its price. It can change suppliers, or it can charge American businesses and consumers more. The final result depends on contracts, competition, exemptions, and supply chains. So a 12.5% tariff does not automatically produce a 12.5% increase on every store shelf, but evidence from earlier Section 301 tariffs is revealing. The United States International Trade Commission studied those earlier tariffs. It found a nearly one-for-one increase in the prices paid by United States importers. The cost can move after it crosses the border, but at the border, the first check is American. The new legal citation does not end the argument. It changes the argument. Small businesses have already filed 2 lawsuits challenging the Section 301 tariffs. The plaintiffs are not claiming that forced labour is acceptable. They argue that USTR used one global conclusion to justify nearly uniform tariffs across 60 economies, with very different laws, enforcement records, and trade relationships. They ask whether USTR proved economy by economy, how each government's policy burdened American commerce. They also ask how taxing most lawful goods would eliminate the identified practice. The administration has a serious response. Section 301 expressly authorizes duties. USTR conducted investigations, held hearings, received comments, consulted governments, made formal findings, and selected rates with exemptions. Using that statute does not automatically violate a Supreme Court ruling about IEEPA, but legality will turn on more than finding the word duty in the law. The courts may have to decide whether the findings were genuinely country-specific, whether the remedy fits the practice, and how far Congress intended this delegated power to reach. The February ruling does not answer those questions. This is the larger lesson. Presidents do not have one tariff power. They have a portfolio of powers Congress delegated through different statutes. One addresses emergencies, one addresses payment problems, one addresses unfair foreign practices, others address national security and sudden import surges. Courts usually review those powers one statute at a time, so when the Supreme Court closes one route, the other routes remain until a court closes them or Congress changes the map. The court's decision mattered. Trump lost the emergency shortcut, but Section 122 kept a temporary surcharge alive. Section 301 then produced a broader, more durable replacement. And American importers still received the bill. The real question is no longer whether the Supreme Court killed Trump's emergency tariffs. It did. So the real question is this: how many other tariff keys has Congress already handed to the presidency? And isn't that the part of politics that usually happens after class?